They told you play it safe, stay where you are, keep your head down, don't reach too far, build someone else's dream instead, trade your vision. Okay, great. So, hi everyone. So, as I said, I wanted to welcome you to this module. Like I said, I'm sorry for the kind of, let me just get the, wait, I'm just letting people in. I just want to get the record set up properly, the view. Okay, just a second. Sorry about that. So just wait. Speaker. Okay. All right. Sorry about that. So welcome everybody. I just wanted to get the record set up, make sure it's going properly. So as I said, I haven't yet shared kind of the basics of engagement agreements. I'm assuming that some of you have found them online. I also have a lot of materials that I'll share on that. I used to do a whole program called the Legal Closet, which gave like dozens of examples of engagement agreements and different types of contracts you would have with like local counsel or contract attorneys. And I'll share those materials with you. But one of the deficiencies in those materials, and also a lot of the materials that you'll find online, is that they don't account for the emergence of AI. And going into an AI raises a lot of questions that you want to address in your engagement agreements with your clients, and also in the agreements that you enter into with expert witnesses or with contractors, or protective agreements that you agree to with your opponents in the part of the discovery process in the court. And so what I thought we would do today is talk about some of those different provisions that you might want to add to your engagement agreement. And we can go backwards after that, and I can do another session just on the regular types of, and I can share the materials too on the regular terms that you would want to include in the engagement agreement. But because we're talking about starting your firm from the ground up, starting with now being the start time, you're necessarily going to have to take AI into consideration. And so, in contrast to some of your colleagues who have had their engagement agreements in place for 5 or 10 years and have to scramble to add these clauses, you can include them right now from the ground up. So, what I'm going to do is go ahead and share my screen because we have a whole show on this. And let's go into share. And let me see. Oh, let's admit. There we go. Wait, where is? Okay. So hopefully everybody can see my screen. It should be AI provisions for your law firm agreements. Hopefully everyone can see that. If you can't, just speak up or say something. Oh, let me see what's somebody's got something in the chat. Okay, great. You can see it. So anyway, I'm presenting this. This is a PDF document. I don't know what I did with the PowerPoint. I was making a lot of different changes because the nature of this law of AI is things are happening like so rapidly, like on the ground, that I think there were even updates that I had to make for cases, within the past couple of weeks. So I was just working on the fly. But like I said, that's kind of what the challenge is. You may have standard agreements or may be able to find standardized agreements online that talk that give you some basis for what you're doing. Wait a second, let me just, is this, I'm not sure what happened. My slide just advanced. Wait a minute. What I said. All right, I'm sorry. Just okay. All right, okay. Anyway, so excuse me, I'll cut that part out. You may have standard agreements that already provide for certain types of arrangements that you have, but they don't necessarily provide for the AI changes that you need to have in place. So with that, we'll go ahead and get started. So this is an update, a substantial update from a presentation that I did in 2024. So that's why I'm using 2024 as the metric. Obviously, ChatGPT came on the scene at the end of 2022. And so these changes are still applicable. And so some of the things that have happened that impact your engagement agreements or your communications with clients about AI are, first of all, the ABA came out with Formal Opinion 512. That was one of the first opinions on lawyer use of AI, and it had some extensive discussion of the kinds of disclosures that you have to make to clients. And ABA 512 takes a very aggressive position, I would say, in terms of disclosure. It says that if you're going to be using AI in a way that materially impacts your clients or uploads confidential information to an AI provider, that it's something that you have to not only disclose, but obtain informed consent for. Now, if you practice now, many other jurisdictions since then, I think 11, I think it's even more than 11 states plus DC. And I have a link in this presentation. I'll point it out. I've linked to all of the ethics opinions that have issued so far. So if your jurisdiction has issued one, you should be able to find it through the link. And so what those ethics opinions have different positions. Very few of them require that same degree of informed consent and disclosure as the ABA 512 does. And we'll go through what some of them say. But obviously, if AI use is something that you have to disclose to clients, that's clearly the place to do it is going to be in the engagement agreement. Another development that we've seen is experts have run into some issues, I would say, using AI. Back in 2025, there was an expert witness who was caught having used, or his expert opinion was found to have AI hallucinations, and his report was dismissed by the court. If you're working with experts in cases, you want to have provisions in your agreement with the experts, first of all, requiring them to tell you if they're using AI and to indemnify you if it turns out that they have used it and their report gets dismissed. So that's another development that you need to account for if you work with expert witnesses extensively. There have also been, of course, 1,300 court cases dealing with hallucinations. Not all have been attorneys. Probably about 500 of them have included attorneys. Where that comes into play is if you are working as local counsel for a law firm and you have to sign off on the pleadings. Some of these cases have found that local counsel was equally culpable for mistakes or hallucinations as principal counsel. And you know that when you're playing the role of local counsel, that's not what you signed up for. You signed up to make sure that these pleadings conform to the court rules and to kind of give an insider's perspective. The judge likes this, the judge doesn't like that. But very few local counsel sign up for cite checking every single citation that's included in a brief. So if you're a local counsel or if you've been retained as local counsel, you want to make sure that your agreement with principal counsel specifies what your role is because you don't want to be on the hook for cases that somebody else hallucinated. And the other thing to be aware of, the Copyright Office still takes the position that AI generated content can't be copyrighted. And so that comes into play if you're working with a marketing firm or somebody who's doing different ad campaigns for you. If they're just using AI to straight generate stuff, you might find out that that material gets ripped off and you don't have a leg to stand on because you weren't able to copyright that information because it was generated by AI and couldn't be copyrighted. So those are other things that you want to account for in your agreement. So this is kind of an overview of all the topics that we're going to drill down into. So the first thing we're going to talk about is what you have to do in the engagement agreement and whether or not to disclose your firm's AI use. And also we're going to talk about clients getting into trouble with AI and what you need to explain to clients, because that was another development that I didn't mention there. There's sort of an evolving series of case law now having to do with what kind of information is protected and whether the privilege still applies if your client takes information from the case and puts it into AI. So we're going to talk about these issues. So the first question that arises is client disclosure required? Do you have to disclose your use of AI to clients? And like I said, we touched on that issue already. The ABA is very stringent about that, but state laws vary. This here is the link to the different state opinions as of July 2026. So if you don't know what your state says, You can click that link when the materials come out and you can see what your state says. California leads towards informing clients about AI use. States like Texas and New York City Bar uh, don't go that far. And it's sometimes it's required in different instances. In some cases, if you're just in most of these opinions, if you're just using AI for general research, like Westlaw or Lexis, you're doing lay of the land research and you're not putting client information in, you don't need to disclose it. The disclosure requirement, at least in the ABA rule and the other states that agree with the ABA rule, is triggered by putting confidential client information into an AI platform. That's usually what triggers the disclosure. My own personal view is that it really is up to the individual attorney. You know your clients. You know what clients would want to be informed if your firm is using AI and which ones don't care about it or which ones would just be overloaded by too much information. So I'm comfortable with having attorneys make that call on a case-by-case basis, and I've got a bunch of different disclosures that you can use depending on how you want to portray it. The other thing is some firms, like my own firm, I pride myself on being very tech forward and also on being able to offer more discounted services to some of my clients because I use AI. And so I very proudly disclose that I use it in the circumstances I use it in. But, again, that really depends on you and what you think matters to your clients. So that's the approach that I would take in this situation. And you have to consult with your bar rules and also figure out, how much this information matters to your clients. I don't know if this, honestly, if this is really going to be an issue 2 or 3 years down the line. AI is becoming integrated so rapidly into everything we do. I think people expect it to be incorporated. So I think unless you're dealing with really highly sensitive information, kind of bet the company trade secrets or highly proprietary information where you have concerns about putting it into a platform, even one that doesn't allow training and doesn't expose the information to third parties, that might be a situation where you'd want to have a conversation with your client. But I think in most cases going forward, clients are just going to assume that it's just par for the course that AI is going to be used and that a lot of times it's going to be used in a closed but cloud-based AI system. So like I said, these are kind of three different options for handling it, and we'll go through each one. I gave examples of each one. You can just give a simple statement, just telling clients that you use it. You can put them on notice, or option C is what the ABA rule requires, is informed consent. And again, check your bar rules to see if that's required. And you may decide that you want to have informed consent. I know there are attorneys who who get informed consent from their clients because that's just the approach that they've decided to take. They feel like it gives them the maximum flexibility in dealing with this information. So there are attorneys who take that approach. So, and these are just three of the different examples. This is option A, which is the very simple statement. This is very similar to what I use in my agreements, just telling the firms. And whatever, and you're not bound to use any of these statements. What I would say though is when you do the disclosure, and this is true for all disclosures, do it in a positive light, not a negative light. Say something, explain why you're using these tools or what the benefits are. So kind of give them the sugar before you give them the medicine about the potential risks. Don't say something like, we think AI is very, very dangerous and we can't be responsible for any types of breaches, but we're disclosing that to you and we want you to sign off on it. I mean, doing it in that way just is a big red flag. So no matter how you frame your disclosure, I would do it, do it in a positive way. And of course, you can use AI to draft all of these tools. And if you're using tools like Spellbook or Paxton or GCAI, they're going to have, built-in products that allow you to also to draft these types of provisions because, they see so many of that. But you can use a regular Claude or ChatGPT to draft these provisions too. So this is just a simple approach. This is one that talks about notice. It gives a little bit more detail about the qualified attorney being responsible for this view. Now, this one also talks about fees. Sometimes you might also, clients may expect if you're using AI that it might have some impact on their fees. This one here says that using AI won't increase fees. Efficiencies are passed along to you. But you might say in your agreement, for example, the state of Virginia allows attorneys to bill for coming up to for learning about using AI tools or for specific AI tools that are procured for a case. So if you have to invest in a very expensive AI product that you might want to pass the cost on to clients instead of having a provision like that, you might say something like, we may invest in an AI tool to specifically benefit your case. We'll seek your authorization, but that cost may be passed on. You can, again, play around with the language, but that may be something that you decide to incorporate into your agreement. And in fact, if you decide to do that, I mean, if you anticipate that you're going to be using, there are some AI tools and by the way, my own personal view is that AI costs shouldn't be passed on to clients. I feel like they're akin to overhead and that attorneys should absorb the cost. But again, if the costs become prohibitive or if you decide that that's the approach you want to take, you probably want to put something into your agreement. So, like for example, if you use a service like Supio or Eve, they charge there's like a per case charge for the use of the product. I don't know if it's like $500 per case or something. So that would be a cost that you could pass on, and you might say in your agreement, you might put the clients on notice that that's a cost that you charge for. Or maybe you have a section of your agreement of your engagement agreement where you talk about costs. But in that situation, if you do decide that you want to pass the cost on and it's something that's measurable and can be tied distinctly to a case, it is something you want to include and notify clients of in the engagement agreement. And then the last one is this is more of an informed consent provision, and this is something that's more akin to what the ABA rule would decide. And the ABA rule is very strict. Again, the ABA rule came out so early on. I mean, it came out in the spring of 2024 before there was really a lot of experience with applying these AI provisions. Um, and so I don't know if it already feels somewhat dated, but they were very stringent in terms of what they required of informed consent and made very clear that it couldn't be boilerplate. It had to be very detailed and explain the different circumstances and the different types of AI that was being used. So this is just an example of that. The other thing that you can do when you're drafting these different provisions for your agreement is you can take if your jurisdiction has an ethics rule, you can upload that ethics rule to ChatGPT or to Claude and just prompt it and just say something along the lines of, this is what my ethics rule requires. Give me some clauses to include in my engagement agreement that'll help me implement this. I mean, that's a very quick way to get the kind of language you need that's going to be tailored to your specific situation. So those are some of the options for informing clients about your firm's use of AI. But there's a flip side now too, because it's not just lawyers that are using AI, it's clients who are using AI. And the way that clients are using it poses two new potential risks. So the first risk is a really serious one. It has to do with privilege waiver. I'm sure that many of you have seen the case US versus Hepner. That was a situation where a criminal defendant, or he wasn't yet a defendant, he was somebody who was being investigated for fraud charges, put a lot of his documents into Claude and did an analysis of his case, which he then provided to his attorney. And the government sought to have it turned over in discovery, and his attorney claimed privilege, and the court found that there was no privilege. It found that there was no attorney-client relationship with Claude. So the client who had put this information into Claude couldn't claim attorney-client privilege. And he also couldn't, the court also found that he couldn't claim work product doctrine because he was doing that in his individual capacity and not at the direction of the law firm. So cases since then have taken different positions. There have been a number of cases on the civil side that have found that if a pro se is using AI tools to research their case and there's active litigation going on, that work product privilege would apply. But the case law is still all over the maps and it's kind of a moving target. And so I think, and it pains me to say this because I think that AI tools can really help clients understand their case and it can also save you a lot of time from having to explain things to them. That said, I think it's really prudent and very important for you to explain to clients what the risks are of them inputting information into Claude and ChatGPT, especially if it's not something that you've authorized and they're doing on the side. And that's just you just have to do that to be prudent and and check the laws of your jurisdiction. If your jurisdiction offers more protection or says or there is some kind of holding that would afford some kind of protection to using AI, you can do that. But otherwise, I think it's really important to inform your clients of that possible risk. The second thing is, and this is sort of, it's somewhat anecdotal, but I think almost everybody has the story of the client coming to their office with the 5-page or 10-page or 25-page ChatGPT analysis of, you know, of different issues, legal issues that come up in the case. And then or they have drafted a contract or taken the liberty of drafting a contract or drafting a complaint, and then they come to you and they want you to just, touch it up or just make a few small changes to it. And they're doing it in the hopes that it will reduce their bill. And I know that attorneys have taken different approaches to addressing that. I've heard everything from one attorney who posted in a Facebook group saying that he would charge like a $5,000 penalty if his client came to him with ChatGPT generated materials. To me, that's really overkill. I think what most attorneys do is just include a provision in their agreement saying, if you provide us with documents that were generated by AI, I understand that as an attorney, I have to review these documents and there is a cost associated with the review. You can put clients on notice that way. I don't think you have to be obnoxious and tell them that the bill is, and I don't think you have to like triple charge them if they do something like that. But it is only fair that if they're producing work for you, just like any other materials that they bring to your office, it's only fair that you be able to bill for that time. So those are two other provisions that you might want to include in the engagement agreement. And these are just two possible ways of doing that. And so this one here on the left has to do with protecting privilege and just it kind of, this is a little bit long. And I mean, that's the other thing too. You can shorten these up. You can make them consistent with your style. Again, this is just suggested language, but this is a provision here that puts clients on notice of the risks of using AI on their case and the possibility of waiver of privilege. And I think, the other thing that pains me about that Hepner case too is that I really think it puts attorneys in a very awkward situation because I'm starting to think that if you don't advise your clients of that risk, you could almost be on the hook for malpractice just because it's something that's so well known. And it's just really troubling that a court decision would put attorneys in that position to, even maybe make their attorney responsible because they didn't inform their clients of the risks of what would happen. But so this way you can have something in your agreement and you can document it. And then here, this is another provision that you might choose to use if informing clients that if they have to review, if you as the attorney have to review something generated by AI, there's going to be a charge for it. So these are just two examples. Again, you can play around with the language, make it conform to your agreement, decide if there's another approach that you want to take. But those are two considerations that you have to think about when you're doing the engagement agreement is not just attorney use of AI, but also your client use of AI. So the next thing is another issue that's coming up in cases is these deep fake issues. So you have situations where an attorney may where a client may come to you and bring you evidence. And these were things that happened before AI. If you talk to any employment attorney or, or any family law attorney, I think every single one of them has at least one example of somebody who had a client who doctored a photo or who did some sort of PDF alteration to a letter or to an email. So this has always existed. It's just AI makes it so much easier and so much less expensive to duplicate things, and it's much more sophisticated. You can really easily dupe somebody's voice and fake a recording or even fake a video based on just like a couple of segments of a person on video. And so it's just much easier to do. And so that's what the problem is. But of course, you don't want to be the person, you don't want to be the last one to know. You don't want it to come out in court that your client gave you fraudulent information. You also, as an officer of the court, don't want to be caught submitting that kind of material to the court. So what you want to do, and there are verification tools that you can use. You can find some online. There are, if you just Google video and authenticity, you can find some AI generated tools that will tell you whether a video is fake or not. And the accuracy is really mixed. It's still an evolving field in terms of being able to tell if things are deep fake. But one thing that you can do at a minimum to protect yourself is you can have these different provisions in your engagement agreement. And this would be in a situation I don't think you need this. You don't need this in every single engagement agreement. This would be in cases where you are relying on your client to provide information for a case that may eventually go to court. So that's principally where it is. I mean, if you're just doing corporate formations or something, or just doing simple contracts, I don't know that you necessarily need to have this in as a standard term. So obviously, mileage may vary. But one of the things that you might want to do is just you can put something in here telling clients that you reserve the right to examine different documents, and also asking them if they have used it, if they've used AI to create any of this. Or the other thing you can do is have them make a certification and just certify in the engagement agreement that the information that they've provided to you has not been fabricated, and that they understand that if it is, it could result in the firm withdrawing, or it could have legal consequences. And I think what clauses like this do is they trigger a conversation. So they put your client on notice that this is not something that they should be doing. It puts them on notice right at the beginning of the case. And so there's no mistakes about it, because I think these are things that are really important to communicate to clients. And like I said, it generates a conversation and a dialogue. And then, down the line, as your client has to gather evidence for a case, they may consult with you. Maybe there's like a photo that they want to crop or do something small, minor to it. The fact that you put this out there and show them that you're aware of these issues of manipulation may prompt them to ask you questions about, what they can do to, when they're providing you with information. I mean, they can probably make, minor edits or cuts if they preserve the original document. So this triggers a conversation. And again, in cases where you're relying on the clients for the evidence that you're going to use to investigate their claims, you really need to have this information from them, because otherwise everybody's going to wind up wasting a lot of time. So the next kind of agreement that firms often find themselves in are contractor and vendor agreements. And these are agreements where issues can come up also. So one of the things that happens is, if you're hiring somebody, a marketing agency or an ad agency, when they're doing the work for you, you're usually engaging them on a work for hire basis. So the content or the creative content that they're creating will become yours through work for hire doctrine. And so that means that you can take that material and you can hold the copyright in it. But the problem is that if they're using content that they've generated entirely through AI with no independent creativity involved, that can't be copyrighted at all. So if they are providing you with that information and you try to copyright it, you're going to find yourself out of luck, you're not going to be able to copyright or protect that information from being infringed or taken by somebody else. The other thing is that sometimes AI content can also be inaccurate. It can, a contractor who's, generating 10 blog posts for you can have AI hallucinate as much as an attorney doing research. And sometimes if the content is AI slop, the SEO algorithms are always changing on how they rank people like that. So if you get information back that's just AI generated and AI slop, it could bring you down in SEO ratings. And so that can be problematic too. So what you want to do is when you if you're entering into agreements with vendors or contractors for that kind of work, you want to make sure that you have a provision about use of artificial intelligence. You want to make sure that the contractor discloses to you any how they're using AI. And this is for contractors and vendors. And honestly, it doesn't even have to just be for marketers. I mean, even more importantly, if you are entering into independent contract agreements with contract attorneys, it's particularly important there because you really want to know if your contract attorney has used AI, especially if you're going to be relying on their materials to make a court submission. So you want to include clauses like this. You absolutely want to have a disclosure about whether they've used AI. If you're working with a contract attorney, I mean, that's your prerogative to decide whether to prohibit them from using AI at all, or at least allow having them use it, but telling them it has to be subject to disclosure. You want them to verify where they've used AI to apply the same confidentiality requirements. And also there's indemnification if any types of issues arise as a result of the usage. So you want to make sure that you have something like this included again in any contracts where you're getting work delivered from somebody else where they might be using AI. And like I said, that applies not just for like creative services, but also for contract attorneys as well. Like I said at the outset, this issue comes up with expert witnesses also, and it's even worse. I mean, the consequences are much worse with experts because, as I had shown or mentioned, referred to earlier, and you can see here, expert reports have been struck because of fabricated citations or hallucinations. And so that can really be highly problematic. And you know that the fault is the malpractice claim is going to be against you if something like that happens. And so it's important to have conversations with your experts about AI usage and AI practice, and also to make sure that there's some sort of indemnification. So these are some of the issues that you can put in to an agreement with an expert. You want to make sure they disclose usage, and you also want to have a conversation with them in terms of, what situations it's appropriate for them to be using AI to generate their reports and what situations where maybe it's not advisable. The other issue with experts, I'm just trying to see if I put this, can't remember if I added this. There have been one or two cases that found recently that certain prompts by expert witnesses are subject to discovery. So if an expert witness it came up in a case in Connecticut where an expert witness had gotten a whole big dump of material and used certain prompts to decide which of the information to focus on in doing his report. So to cull the information. And the court found that those prompts that were used to decide on the culling process were substantive, and they were something that the other side was entitled to ask for information on, or it was entitled to get in discovery. And so the court required that to be produced. And that was something that's contrasted with just an expert witness just generally using AI to kind of do broader research of different theories or things like that. That's still protected product or protected as a draft. But if they're using it to decide, if they're using it in a way that is more of a methodology, like a methodology that they use to analyze the data, then it's something that has to be produced. So you can take a look at those cases. I think I'll cite them in the course materials, and you may want to have a discussion with your expert just to prepare your experts for knowing what type of information may be subject to discovery and what might be privileged. So in addition to having a discussion about using AI, and the other thing you want to remind your experts of too, I saw this happen also, I saw somebody who had posted a story on one of the social media sites where he was reviewing an expert report and he was running, like trying to figure out if the expert had used ChatGPT. So he started seeing phrases like "certainly I will" in the expert report, saying something like "certainly I'll verify that for you," and that became a signal to this attorney that the expert had used AI, and he just basically assaulted, or he was able to, in the deposition, just really go after the expert and ask him about what he had used AI for, and he just really decimated his testimony and his credibility. So the other thing is too, is if your expert is using AI, they should be telling you they're using AI, and at the very least eliminate any telltale signs that they did use AI, because it's something that's going to come up in the deposition. So these are conversations that you want to have when you work with experts. I think putting this information into the engagement agreement kind of starts that conversation, and it's the bare minimum. But in addition to just putting these terms into an expert agreement passively, you want to have good conversations with your expert witness about ways they should be using AI and ways that it could potentially harm their credibility. And I think in this particular case that this attorney was talking about, he was able to get the expert to admit that he had even asked ChatGPT some of the most basic questions that he really should have been qualified, he really should have known without having to ask AI about. So it was really very devastating. Like I said, you want to have indemnification clauses in for experts. So the last type of issue that is coming up now, and this is really an issue that's in progress and underway, is protective orders and NDAs in court cases. So if you're ordered to produce documents in discovery, the issue was coming up, well, can my opponent take that information and put it into a public AI tool to analyze, because obviously you don't want your client's confidential information going there. And so courts are taking a lot of different approaches, but this is really what the problem is. So courts are now beginning to add express AI provisions to protective orders and discovery orders. And this is something where if the court doesn't add something, you may want to take the offensive or be proactive and propose that something be added so that you can protect your client's information. I mean, even if you're in a family law case, do you really want some, opponent who is, you don't know what kind of AI tools they're using, being able to upload your client's bank accounts and other types of sensitive information into like a public chat GPT? You don't know what the opposing counsel is going to do. And so you want to be able to propose terms for the disclosure and for what type of AI can be used. Now, in this situation, I mean, I think that you want to take a fair approach. I don't think the goal is to prohibit the other side from using AI, because, be careful what you wish for. If you're going to have a very prohibitive clause that says, no information can be uploaded into any AI platform, that means you're not going to be able to use AI to analyze discovery, and you're going to shoot yourself in the foot. But I think it is reasonable to ask that if AI, and for if your client's documents are being uploaded into AI, that the other side at least be working with tools that don't train on the AI, that don't expose the information to third parties, and that follow the other types of criteria that you would use to select a secure AI tool for your own practice. And I have materials on that too, on terms of selecting secure tools for your practice. So in here, this is there's an order called Bellas, and I'll provide that in the the course materials. But that is a case out of the Southern District of New York, and it gave a very detailed discussion of the types of AI tools that could be used by the other side and that couldn't be used by the other side. And essentially, where the court came down is, like I said, they came down with ultimately they prohibited use of AI if it wasn't secure, but they said nothing bars a secure, closed business enterprise self-hosted or HIPAA compliant AI system that doesn't train or expose material to non-parties and is protected by reasonable safeguards, provided its use otherwise complies with the order. And I think that I know that that is kind of vague, but I think that until we know more about how these tools work and know what kinds of tools we have, I would be comfortable with something like this because it at least ensures that most parties will have the opportunity to use AI without having to invest in some very expensive enterprise tool or expensive e-discovery tool that might be cost prohibitive for many solo and small firm clients. So you can take a look at that order. And I think that if you're doing litigation, I think you want to come prepared with some kind of language that you can provide to the court to give to them in those situations and, to ensure that you can protect your client's information also. Oh, and this is just, yeah, that's the other information. So another thing that some people have started using AI for are doing like chat bots at their website and I mean, even before AI, people were using chat bots. It's just important that you want to have certain disclaimers if you're using a chat bot at your site. One thing that you do want to do that I haven't mentioned here, which I should have mentioned here, is that I sort of mentioned, I said the assistant isn't a lawyer. There are some states that require you to disclose if a chatbot is to disclose that a chatbot is AI generated or is not a human. So you may want to add that to your disclaimer, but you also want to tell people that it's not providing legal advice, it's informational only. Um, that's to sort of protect against UPL and to make sure that an attorney-client relationship isn't created. So this is one example of a chatbot disclaimer. But again, if you are in certain states, I think Connecticut, Utah, maybe New York, there are certain jurisdictions, and these are not ethics rules, these are state laws that require you to disclose if an AI tool is dispensing information or dispensing advice. And so you would need to comply with those state laws in addition to compliance with just general ethics and common sense of those disclosures. And then the other issue, where are we not? The last thing is there's this whole concept of AI washing. This is also becoming less of an issue now because now really most tools actually are using AI. When AI first came on the scene, a lot of companies were holding themselves out as their tools were using AI when they really weren't. So it was called AI washing. And the FTC and the SEC have actually gone, there are one or two cases where they went after companies that were promoting use of AI as part of the services that they were providing or the tools that they were providing when AI really wasn't involved. So the same is true for attorneys. If you're going to hold yourself out, if you're going to say our firm uses AI in every step of the process and we generate all our documents with AI, if you have that kind of information there, you just want to make sure that it's not deceptive and that you can back up a claim like that. Now, why an attorney would you would have that kind of information on their site, I don't know. I mean, some of these AI native law firms, maybe, this is something that applies more to them because they're really going all in on just AI generated materials with very little human oversight. But I think most firms are more likely to promote the human element of the service they're providing rather than AI. But it's something to consider if you're going to be talking about your AI usage. You just want to make sure that what you're providing on your website, the information and insight you're providing is not deceptive. So, and here's just, this is a checklist that you can have to go through all of these as you develop your engagement agreement. But these are just some of the things to think about. These are a whole bunch of new issues to include in your different agreements as we enter this exciting AI age. And like I said, I will provide some other materials, just sort of general sample engagement agreements that you can use or that you can feed into ChatGPT or Claude to have it generate an engagement agreement. But in addition to those terms and conditions, there's also these different things you want to think about. So that is the end of this presentation. Does anybody have any questions, or has anybody had any issues that have come up that weren't covered here that maybe warrant some sort of contractual term or provision? Okay, so I don't see that we have questions. So anyway, yeah, so like I said, I have been behind in getting these materials um, edited. I'm going to try to get the other recordings edited, and now I have this one to add, but this should be ready to go out in the next couple of days. And we should be having another segment towards the end of the week on the ethics of the AI native law practice. But I think I may also do, maybe I will do just a quick module on just engagement agreements, just the basic terms, which I probably should have done before this one, but I was so excited to get all the AI terms and conditions out there. So we'll see what segments we will be covering this week. And then in the next couple of weeks going forward, we'll address some of the topics. I just have gotten a little backed up. And so we're just doing this on a revolving basis. But by the end of August, you should have a whole bunch of materials to help get your practices off the ground. So, oh yes, and I also am going to I'll do a recording or maybe a section on using AI to manage your email. I know somebody asked about that. And if there are any other topics you want covered, just send me an email or drop something in the chat, because this is just very flexible. I'm looking for topics that people are interested in. So, does anybody have any other questions? All right, so watch. Oh, wait, we see something in the. Okay, great. Okay, I'm good. This is helpful. Very good. Okay. Yeah, if you have any follow-up questions, let me know. And like I said, I should have these materials out, so you can just feel free to screenshot stuff and get it into your agreement. So anyway, thank you all so much for coming, and I will see you next week. And thanks for, participating in this evolving series. So anyway, take care and have a great rest of the afternoon. Bye.